Today, on Rochelle's Daily Wire, video edition, we commemorate the National Conference of Bankruptcy Judges occurring today in Austin, Texas. We salute the NCBJ by reporting an important decision regarding Subchapter S corporations. As you know, a Subchapter S corporation itself pays no taxes. Rather, if there is any tax liability, it passes through directly to the owners. On the other hand, if there are losses, the losses and other tax attributes flow directly to the owners. This is all fine and dandy, but if the Sub-S corporation ends up in bankruptcy, there can be significant tax results with respect to the owners. For instance, some transactions in bankruptcy, such as sales of assets, might result in a substantial tax liability that would ordinarily flow through to the owner. In those circumstances, you will see the owner endeavoring to terminate Subchapter S status so that the tax gains or tax liability is paid by the corporation. Well, there is a split of court decisions on whether or not owners have the ability or the right to terminate Sub-S status. Several bankruptcy courts have held that Sub-S status is an asset or property of the bankrupt estate, and therefore the automatic stay bars the owner from terminating that tax status. On the other hand, the Third Circuit in 2013 held to the contrary and said that Subchapter S status is not property of the estate, thereby freeing the owner to terminate Sub-S status and, I guess, cause the tax liability to rest on the shoulders of the bankrupt corporation. A few days ago, bankruptcy judge Peter Rusin from Fort Lauderdale, Florida, wrote a very important, lengthy decision disagreeing rather pointedly with the Third Circuit and lining himself with the bankruptcy courts, which had found that Sub-S status is indeed property that is protected from termination by the automatic stay. If you happen to be in a bankruptcy case involving a Sub-S corporation, and if these questions of Sub-S status, termination, and tax liability arise, I recommend that you read Judge Rusin's decision, his lengthy decision, in full text. I am Bill Rochelle, the Editor-at-Large for American Bankruptcy Institute. I shall return same time next week with something interesting from the world of bankruptcy. Until then, be well, stay safe, enjoy the NCBJ. Good day.